System's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm. United and free. United and free. United and free.
We're going to have some witness testimony coordinated by the prosecutor's office. Then we'll hear from the prosecutor's office on their sentencing proposal, the response by defense counsel, and the statement by Mr. Sharpe, if any, and then the court's decision. Obviously, for most of you who've been following this, Judge Price was the original judge on this case and oversaw this case for many years and did the full sentencing some time ago. The case came back to us from the Court of Appeals. Judge Price is retired. I was the person appointed to fill his spot, and that's why you're seeing me here today. The parties provided the court all the impact statements. There were 174 statements. Those statements we're all here. We have a list. I didn't make copies of all the statements, but we do have a packet of all the names of the people who made statements, if you want to see that, along with the brief filed by the state and the brief filed by the defendant. And the court read all those statements line by line. And then also the court reviewed the transcripts of the several days of the sentencing hearing where so many people from the community participated and shared with the court the impact of them, of what had happened, both at the time and in the several years after that. We will have a chance to hear from any witnesses that want to repeat, not word for word, but whatever their testimony is. And that's guaranteed under our Constitution, and also the state legislature has passed a law. There were dozens and dozens of people who testified last time, and the prosecutor is the one responsible for reaching out to people to see what works for them, if they want to testify or not testify. And I am now going to turn it over to Mr. Jolstad, for any witnesses for today. But just know that the court did review all the transcripts of the previous testimony and all the statements.
Thank you, Your Honor. Your Honor, Miss Amy Strahan would like to speak today. She is the mother of Sam Strahan, who was killed those many years ago. And
Okay.
I believe the court has given her permission to speak from the witness stand.
Yes, she may step up to the witness stand. And counsel, do we swear people in on this? I don't think so.
No, Your
but,
Honor. No.
Okay, all right. Hi, Ms. Strahan. You can come right by this way. And then right in the witness chair there. Welcome to this court, and you have as much time as you would like to share what you would like.
Thank you. I debated on reading the whole thing, but when you said you'd already read it, you've already heard that part of my story. So I just wanted to add just a few things. For today, I like to sit here because I really want to make sure that you see me and that you see what you did to me and what you did to my family. Same for you. That's why I choose to sit here. It's been 749 days since I last addressed this court. The evil human who took my son, his pathetic parents, and a courtroom full of onlookers. It was here that I was found guilty due to a vain witness and a fragile public defender. I sucked it up like all the times before, having to stand and wait to get into a courtroom while those who contributed to this nightmare received their safety escort. I read through all the documents. I sat through 2 years of hearings just to determine which court was going to take this case. It took another 3 years to get to the initial sentencing. I've held back anger, debilitating sadness, and rage. I took the high road while I watched you sit and stare blankly without any remorse. I did it, and I honored my son by sharing what that day did to me and to those who loved him. We walked out of this courtroom August 19th of 2022 and didn't look back. I tried to rebuild. I tried to get moving with forward momentum. I made small steps, some internally and others to literally move my body. But I was moving. On April 16th, 2024, I got word through the media and soon from people from Spokane who saw the news. Despite the fact that the prosecutor's office reported the victims were aware, I had no idea what was happening. None of us were aware of what was happening. To add insult to injury, received an email that stated, "This is in fact, the first time in 26 plus years as a prosecutor that I have reached out to the families of victims to notify them of an appellate result." First time. I find that shameful. We all had questions, and we were all told that there were no answers available. I was told that every single attorney and judge that looked through this case missed one sentence. Let that sink in. These are your elected officials. I feel these attorneys and officers wasted precious time, untold amounts of money to determine that after all the evidence, his plan, his 400 plus rounds, and his loaded weapons, that 25 years to life is the most. I ask you, if his AR-15 hadn't jammed in the hallway, and instead of one life, he shot 20, 30, would that be different? Or would he just get 25 years to life? Doesn't matter how many. That's the statute, correct? Okay.
For your questions, but I
Great.
appreciate why you have them.
Yeah. I don't know anyone who feel justice was served. Thank goodness it was just the one, right? The one you took. It was mine. The wounds from that day remain deeply painful. This, coming here and doing this again, very painful. I'm here for Sam, and I will always show up for him, regardless of how much this hurts me. But it bears repeating that this nightmare will never be over. There are long-standing wounds that won't heal because they simply can't. My disdain for the court system is fueled by being witness to the dismissal of victims. It doesn't matter what side you're on, the victims are the least of anyone's concern. I realize speaking again is also fairly futile. The decision is made and my words will not make the punishment any harder. I speak because I'm Sam Strahan's mom, and I want to be sure that my feelings are at the very least heard. Sam lost his life to the soulless man that sits in this courtroom. The legal system has chewed us up and spit us out. The 7th anniversary is in 1 week, and we're still sitting in a courtroom. The delays, the motions, the battles over discovery and blood splatters. This system and the process is brutal and life-altering. You are a coward, hiding behind the veil of Jesus Christ. I spent years working for the Department of Corrections here in Washington, and I'm well aware how easy it is to turn to Christianity when you're behind bars. But I'm also very aware of how that changes once you're not bound to your cell. I can only hope that even the Lord Almighty will see that you are not worthy. You have shown no remorse, ever. You sit here blank, always. You deserve to rot in the darkest spots of hell. I wish you and your loved ones a life of pain and suffering. I hope on days when life throws you down, the universe kicks dirt in your face just for good measure. And I hope my son haunts your dreams until your very last breath.
Mr. Jolstad, you would like to make the state's recommendation and explain why the state has its recommendation.
Thank you, Your Honor. Yes.
And just before you do that, can you just confirm for everyone that you offered the chance to other people to testify and they chose not to at this time, understandably?
We did, Your Honor. As Ms. Neighbors, who sits in this courtroom, and I have worked together to reach out to the families of the victims in this case and extend an opportunity for them to speak should they choose and is their right. We let them know that they could appear by Zoom to testify if they wish to, if they could come and write a statement, have Ms. Neighbors read it, or have another individual read it. If they wanted to come and read it themselves, that was also an option, or just to come and speak. Having practiced in DV for a significant number of years, it is always important to me to give the victims that opportunity to testify and to, face the person that's been convicted of the crimes in which they've done. So yes, we did in fact reach out to everyone and let them know they had that option.
Okay, thank you.
Your Honor, we're here because in 2012, the U.S. Supreme Court made the decision that children are different. In Miller v. Alabama, they stated that because there is so much science put into effect, that the juvenile brain or the youthful brain, depending on the age of the individual, changed. From that decision, many things have happened legally, federally, and also here in state of Washington. Unfortunately, as we come here on this resentencing, we're here against the backdrop of another school shooting that took place in Alabama and Georgia that was done by an individual only a year younger than Mr. Sharpe when he committed his offense. So that is an unfortunate fact, even given the laws that have changed, because they have changed. And unfortunately, they've changed in such a way, as you heard from Ms. Strahan, that victims often get devalued. They come here for a resentencing because the laws have changed. Whether fair or not, the rights we try to support with our victims, the rights that they are given both through the Constitution of the state of Washington and by statute, sometimes seem to matter very little when we reach the appellate court levels. And unfortunately, that's also the case when we have victims, as in this case, that are seriously injured or unjustly taken from the earth, as Mr. Strahan was. But the law did change. We talk about it as what we term the Miller fix. Essentially, it changed RCW 1095-030, and it created three distinct sections. The first one being if you are below the age of 16 at the time you committed aggravated murder or murder with aggravating circumstances, you can only be sentenced to 25 years to life. That is the situation that Mr. Sharpe finds himself in, being 15 at the time this event occurred. So that was a sentence that was required. Secondly, we have those between the ages of 16 and 17, where the minimum is 25 years to life. So had Mr. Sharpe, I believe, only been about a month and a half older, the sentence that he was given potentially would have been found constitutional by our Division 3. And then you have the last section, which is 18 and above, which until Carter Wright about 2 months ago was life without the possibility of parole. Now we have an area that the court has given us, which is fairly vague, where a person 18 and over sentenced to, convicted for aggravated murder can be sentenced anywhere from 0 to a life without the possibility. Courts are granted complete discretion for those over the age of 18. It's incredible that that is where we're at. But regardless of that, that was the statute that was in effect at the time. It was a statute that was in effect when Mr. Sharpe went to Freeman High School. It was a statute in effect when he committed this heinous crime, when he injured Jordan Goldsmith, Gracie Jensen, Emma Nees, and then shot Sam Strahan. That was a statute in effect at a time. It was the statute that was in effect during the entire declination hearing, as well as his initial sentencing in front of Judge Price. Mr. Sharpe rightly appealed that sentence, as is his right when a person is convicted and an error in the law is found. And the Court of Appeals agreed. The state conceded that he should have been given 25 years to life. Unfortunately, Judge Price handed down what could be termed an illegal sentence for count 1. Not for counts 2 through 5, but count 1 solely, which was the aggravated murder charge. Despite the desires of the victims that we talked about that sometimes get pushed under the bus, despite the desires of Mr. Sharpe or his family or the state or even Your Honor or Judge Price at the time, the law requires that the court sentence Mr. Sharpe to 25 years to life, that 1095-030. The fact that the statute was missed by all parties, not just the state, but the public defender's office, Judge Price, the attorneys who originally crafted the plea agreement that occurred, I believe, in that January, the fact that they all missed it is kind of horrifying because it's very simple. It's inconceivable that happened, but it did happen. The victims in the community that have been trying to put this behind them as best they could instead are here again for a second time, and that is very frustrating. That is why the agreement of the parties at this particular time with respect to count 1, which was the aggravated murder, is to just apply the statute, apply 1095-030. It is this because that's what the statute requires, and hopefully add some finality, at least judicially, to this issue. We can send it to bed, and hopefully we won't have to drag the victims back through this again, which is both a horrifying process and a frustrating process, especially when this event happened 7 years ago next week, as Mr. Strahan reminded us. So that is the party's recommendation to the court for count 1. As far as counts 2 through 5, which address the injuries to the 3 young women who survived, and than the assault charge, which lists all the remainder of the victims who were in the hallway at that time. The court is required per Miller v. Alabama to take into consideration the youthfulness of the offender to determine whether or not there are mitigating factors that allow the court to go below the standard range. As case law has made clear, specifically through Houston Sconiers, the court has to conduct this inquiry. Now, Houston Sconiers applies only to the SRA, or the Sentencing Reform Act. It doesn't apply to 1094, which is why the court has to sentence him in that 25 to life range. However, it does apply to the SRA, or counts 2 through 5. Judge Price took into consideration those mitigating factors when he handed down the sentence. Your Honor has read the transcript. Judge Price made a very thorough ruling. He discussed in length Greg, which says that age alone is not a mitigating factor, that the burden's on the defense to show that, those factors are there. And he took into consideration also Haig, which is a case that is quoted in the agreement of the parties, which essentially says that 46 years is a de facto life sentence. Judge Price did discuss that at length when he handed down the sentence, because of the fact the sentence that he had imposed originally was the 40 years to life, and it was so close to that 46, which had been declared a de facto life sentence by the court. But he took all those things into consideration, and it's the state's position that this court, having reviewed Judge Price's findings, having had the opportunity yourself to review the statements, I know Your Honor held them up, but there were many statements, and these are not all those, because there were some that were given in court as well. So many members of the community that were affected, families, friends that were affected by this. But the court can take that all into consideration. The court can take into consideration Judge Price's ruling and can adopt that and supplement it, or just adopt it itself, I believe is appropriate to make these findings, these Miller findings. The court, because of Houston Sconiers and because of the Miller factors, has unlimited discretion on what the court can do with juvenile offenders. The courts have held that this is important because, like we said at the beginning, children are different, is what the court would have us believe. And so the court has the ability to go below the standard range, or the court has the ability to follow the standard range. As laid out in the agreement of the parties, the normal sentencing for an individual with convicted of murder in the first degree or attempted premeditated murder in this particular instance is that the first one is where you calculate the score, or whatever the most serious charge is. Because they're all the same, you can start with the first one. And then the other ones are zeroed out. And then the court runs consecutive those sentences. So the court would run counts 2, 3, and 4 consecutive if this was a normal sentencing. The court still has the ability to do that, but if this was a normal sentencing, the court would have no discretion to do that. Here, however, because of Houston Sconiers, because of its prodigy, the court has the ability to run them concurrent, which is what Judge Price did. Judge Price not only ran them concurrent, but he also imposed the high end of the standard range, which was the 240 months. And he ran those concurrent with the aggravated murder as well, which at the time really didn't matter because they were lower than the 40 years at the time. Here, still it doesn't, because you're doing 25, and those 240 months essentially end up being 20 years. But Judge Price did go through the analysis. He went through the Miller analysis and found mitigating factors. At the same time, he also found that there were significant other factors, which is why he gave the high end, such as the planning, such as the injury to others, the depravity of it, things that he mentioned on the record at the time. So he did do the high end and then ran them concurrent, which again, that is what the parties are requesting in this case, because that is what Judge Price imposed at the time. That sentence was not appealed, but because we are back at a de novo resentencing and the court has the ability to resentence on everything, that is the request of the parties. The request of the parties as to count 5, which is the assault, is the same, to do the high end there and run that concurrent with counts 2, 3, and 4. As far as the rest of the conditions, at the time of sentencing, Judge Price imposed life as a part of Department of Corrections. That again is the request, that that the court would impose life, so he'd be on probation essentially for the remainder of his life, whenever the ISRB would choose to release him from custody after, I believe it would be with good time, 24 and a half years, when he'd be able to petition for release. So those conditions that were imposed by DOC were no contact provisions protecting the three young women that were injured, as well as Miss Amy Strahan. Those were to be imposed for life, which was the length of the sentence and can still be imposed for life. And so the state again would request those. In speaking with the families of the young women, that is their request as well. I did want to point out in saying that I know that none of the young men are here. However, they said they would be here if the state had felt it was necessary. So I don't want to make it look like they had no interest in coming here today, because they very much are interested. But I feel that they don't want to give any more power to the situation at hand. But they were willing to come and to testify. But given that we had an agreed recommendation, I told them that I did not think it was necessary at this time. But I did want the court to be aware of that they were willing to come and are very much vested in the outcome of this. But those no contact provisions, we're also asking for the no contact provisions, which were imposed to those, I believe, 50 individuals that were on count 5. Those would only be statutorily allowed for 10 years, which again would be before Mr. Sharpe would be able to leave custody. But I think it is important to have those no contact provisions in effect. I think that they give the victims not only peace of mind, but protection from maybe an offhand contact. So I do believe those are important. I would ask for those. As far as other conditions, it was required that he have a mental health evaluation and treatment. I don't have documentation whether or not that was completed. So again, I would ask that would be imposed. If Mr. Hargett can correct me on that, he can, because I was unable to find out if that had been accomplished. The only other thing that was imposed was the legal financial obligations. The laws have changed since Mr. Sharpe was scheduled the first time in regards to legal financial obligations. They are retroactive. So at this point in time, I believe the only legal financial obligation that can be imposed, given that he was represented by Public Defender Counsel at the time, so indigent, would be the restitution. I did put the wrong amount.
I was going to ask you
good.
that.
Oh, good. I did put the wrong amount because it had changed shortly thereafter, and so I missed that. So it is, I believe, 39,000 number, not the 36,000 number that was initially given to the court.
There's a number of 37,116.22.
Okay. There was a
Another one. That was the amended one.
yeah. So there was an amended one in February that had 39,961
Right.
and 83, and that's still in the file. So the state's request would be just for the JNS to refer back to the amended restitution. That way, we wouldn't have to enter a new restitution order at this time, as that's already been entered.
Until it was 39,000.
$961.83. And the time payment, I believe, was imposed at $25 a month whenever the court wanted to start that out at. But that is essentially the basis for the joint recommendation of the parties. A lot of it, as I know Mr. Hargett will speak to, that Mr. Sharpe wants to get this over with. He wants to go back to Green Hill. A lot of it, I think, is to end this case, because the pain and suffering that it continues to cause the family, dragging them back in almost 7 years. That's a long time for any homicide, let alone a school shooting. While there'll never be closure for the families that suffered through this tragedy, especially for Ms. Strahan, I think that judicial closure is important. I think the fact that we would not have to hopefully come back here and do this again and again and again would be something of a boon, even if a small one. I know that nothing that we do here can bring back Sam Strahan or take back the injuries, psychological, emotional, physical, that were done that horrible morning. But we can do at least stop dragging them to this courthouse and stop making them relive the event in front of an audience every time. And so I think that the resolution of the parties is appropriate. I have had this case since the mandate came back and not before. But in looking through it, I think that this is appropriate. Again, I don't understand why we were here, why it was crafted the way it was, how it was missed by everyone. But it was, and we are here. And so we would ask the court to adopt the agreed recommendation, and again, to hopefully put some sort of finality in this case. Thank you.
Thank you so much, Mr. Jolstad. Mr. Hargett, what would you like to tell the court?
Thank you, Your Honor. Counsel, may it please the court. The reason we're here today is because the previous sentence my client received in this case violated Washington state law. Neither Your Honor, Mr. Jolstad, nor myself were involved in the previous sentencing, or were involved until recently after the mandate returned the case to this court. On appeal, the state conceded that the sentence was not lawful. The Court of Appeals returned the case for resentencing. The Court of Appeals held, under Washington law, the correct standard range sentence in this case for count one was 25 years to life. Additionally, the Court of Appeals left open for this court to decide whether there was a legal basis to consider a sentence below the standard range based on youthful offender factors. Initially, when this case was returned, this court asked the parties to brief these issues. However, my client accepted an offer from the prosecutor for a joint recommendation for a standard range sentence of 25 years to life, all counts and enhancements to run concurrent. This sentence would be consistent with the ruling of the Court of Appeals. The state, in its most recent sentencing brief, also pointed out the laws changed concerning the LFOs. I agree it's appropriate for the court to consider indigency concerning the LFOs only. As far as the restitution, we would agree to the amount the state's requesting. I think that that's the most important thing for my client to work on, paying back the restitution in any event. Against advice of counsel, my client has chosen to accept the state's offer. The reason my client wants to accept the state's offer is because he does not want to prolong anyone's suffering or prolong the ordeal that people have been through. But to be absolutely clear, my client would have been well within his legal rights to ask his attorney to advocate for a sentence below the standard range based on Houston Sconyers, Miller, and the other youthful offender case law. This is a developing area of law, which is changing rapidly as we gain more and more understanding about the science of juvenile brain development. Had our client agreed, we would have done further work with Dr. Adler and Dr. Bieber, which would, we believe, have augmented the original work done in this case. The QEG scans that were done when my client was 15 years old and 18 years old had already shown significant brain development. We believe if he had another scan done at his current age, 22, it would show even more development. In Houston Sconyers and other youthful offender cases, there's a lot of discussion about the difference between juveniles and adults and how their brains work. Juveniles tend to be more impetuous, make rash decisions. They are less able to comprehend the consequence of their actions. They have poorer judgment. And we've always known this to a certain extent, and that's the reason why we don't let kids drive until they're 16. We don't let them vote until they're 18. We don't let them drink alcohol until they're 21. There is no context or mechanism in the United States where a juvenile could argue they should be treated like an adult or given a driver's license or alcohol when they are underage. We would never tell a 15-year-old that they seem like an adult, so we could ignore those rules. The science that we've learned in recent years show why children are different from adults. Their judgment and reasoning skills are not the same as adults. The science showed that our brains are not fully developed until well into our 20s. We would have liked to have an opportunity to do more work on this case and be able to present additional evidence to this case for the court to consider. However, doing so would have meant that sentencing would have taken several months. By accepting the state's offer, my client's hope is that this will give closure and finality to everyone who was affected by what happened 7 years ago at Freeman High School. The arguments I'll make today will reference some of the mitigating evidence that's already been part of the record in this case. But again, just to be clear, Your Honor, my client is only asking the court to consider these mitigating factors for the purpose of following the sentencing agreement. He is not asking for a sentence below the standard range. The first thing I would ask the court to consider is that you are not sentencing the 22-year-old man who's sitting here before you. The person you are sentencing is actually the 15-year-old boy who made a terrible decision 7 years ago. My client is not the same person he was back then. One of the things a court is required to consider when sentencing juveniles is their potential for rehabilitation. The experts who evaluated my client and from both the defense and the prosecutor side all agreed that he has potential for rehabilitation, good potential. And that point now is not just theoretical, because several years after his sentencing, we actually have information we can provide to the court to show the work he's done towards rehabilitation. To begin, he's been a model inmate with no infractions. He's completed his GED and was chosen as a speaker at his graduation class. I included the defense brief, a letter from one of his college professors. It shows that he's maintained a GPA average of 3.9. He's made the presidential honors list. He's been invited to join Phi Theta Kappa Honor Society. And now he's just a few credits shy of completing his college associate's degree and on track to graduate with a bachelor's degree in 2026. He's had original poems and stories published in his college journal. His professor describes him as my client as a caring person with a bright future. How do we square that description of my client with what he has admitted to doing and pled guilty to doing at Freeman High School 7 years ago? How do we ever explain any of the school shootings or mass shootings that occur in this country every single day? Other countries don't have these mass shootings occurring with the frequency and regularity that they happen in this country. School shootings were almost never heard of when we were kids, but for our children, these events have become normalized. Some have even described them as a fact of life. Well, our children should not be asked to grow up in a world where school shootings are normalized. That is a failure on our part. Since Columbine, there have been about 416 school shootings, including the one that happened this week in Georgia. Our country couldn't even get through the first week of school this year without a school shooting. And mass shootings are even worse. In the last 7 years, there have been 4,011 mass shootings in the US. There are lots and lots of theories about why these happen, but all these cases seem to have some similarities. It usually involves a young person who sees himself as a loner or outsider, who is struggling with mental health issues, who feels unrecognized, unacknowledged, or bullied. And most of us growing up have experienced those things at one time or another, feeling bullied or feeling like an outsider. Most of us didn't resort to violence. So why does it happen so often now? The common denominator seems to be mental illness or childhood trauma and easy access to guns. Some also believe the news media and social media have exacerbated the problem. Every time we have one of these mass shooting events, the news helicopters swoop in, show terrified people, often young students fleeing for their lives. Some believe that the way the news media focuses attention on the shooters actually encourages copycat behaviors. Kids see this stuff on TV, on the news, and their takeaway is, this is how to get attention. This is how to get famous. This is how to stop bullies. Some are suicidal and are just hoping to find a way to kill themselves. But kids go on the internet and they find sites that glamorize violence, social media and algorithms designed to stir up conflict and amplify cyberbullying. We live in a society where violence is often seen as a solution to problems. It is not rational for a young person to hurt others and throw their own lives away in the process. But as Houston Scaniers and other youthful offender cases point out, the hallmark of youth is making impulsive, short-sighted decisions. You have the records before you, including the testimony of Dr. Adler and Dr. Beaver. The QEG scans and other testing show that my client at the time of the incident, although he was 15 years old, had the brain development of a learning disabled 11 or 12-year-old. I provided the court with transcripts from the original sentencings, including the victim impact statements. Those statements are very consistent with all the homicide cases we've ever seen in Spokane. In every single case, the victims and the family will always ask for the maximum sentence. Whatever sentence the court imposes, the victims will always say it isn't enough. And they're always right. It is never enough. There is no amount of time any court could impose that would adequately compensate a grieving family member for the loss of a loved one. I've never met Ms. Strahan before, but my heart does go out to her. When the legislature wrote our sentencing guidelines, their intent was to provide a structure, fair and proportionate sentencing not based on emotion and passion. The sentencing guidelines and statutes govern what discretion courts have when imposing sentences. They provide the courts to take into consideration the mitigating factors as well as other factors. With juveniles, courts should take into consideration the defendant's youth, mental health issues, lack of any prior criminal history, and in a case like this, the court can also consider defendant's subsequent efforts to rehabilitate himself. Acceptance of responsibility is also something the court can and should consider. In this case, Caleb didn't exercise his right to go to trial. He pled guilty and accepted responsibility. The issue that comes up a lot in cases like this is a misperception that people think a defendant has not shown remorse. The problem with that, of course, is that our criminal justice system is not set up to allow defendants to communicate with victims while the case is pending. They are arrested. They are told immediately by police they have the right to remain silent. They are brought to court for first appearance, and the court tells them they have the right to remain silent. If you talk to their attorney tells them they have the right to remain silent. As a result, most of the time, the victims never hear a word from the defendant until we're actually at sentencing. And by that time, it always feels like too little, too late. There's always frustration from people who don't understand why cases take so long to get resolved. We appreciate that this court understands well the reasons why a case like this takes as long as it did. The case started in juvenile court and initially had to go through the declination proceedings. There were different attorneys involved at different times. There were doctors and experts who had to be consulted. Given the number of witnesses and the number of charges involved, this case obviously was going to take longer than other cases. And it should be noted that my client's original attorneys had attempted to litigate even further to seek discretionary review, and they wanted to take this case to trial. But my client eventually told his attorneys, no, I just want to plead and get this over with. I don't want this to go on any further. Even when he didn't have a firm plea agreement as far as what the sentencing recommendation was going to be in the original case. Originally, each side could argue for whatever they wanted at sentencing. And this case didn't go to trial, even though there were obviously defenses that he could have raised concerning mental health issues. My client ultimately chose to disregard the advice of his attorneys, which is his right to do. He chose to plead guilty and accept responsibility for his actions. And now he again chooses to forego litigation so this matter can be quickly resolved and without further ordeal to anyone. For anyone who is hoping to see my client spend the rest of his life incarcerated, that is a possibility under this sentence. A sentence of 25 years to life does not mean he's automatically released after serving the minimum amount required. After he has served the minimum amount, he will be required to go through a review board and prove that he has earned consideration. What my client did 7 years ago when he was 15 years old caused great harm. He took the life of his classmate. He injured 3 other classmates. He caused grief and traumatized the Freeman community. The ripple effects of an event like this are difficult to even quantify. One of the common things said by the original sentencing, especially by the students who were there that day, said it took away their sense of safety. Several people said they never thought anything like this could happen at Freeman High School. The sad reality in this country, however, is that these shootings are happening every day. There is no place in the U.S. where they don't happen. There's just places where they haven't happened yet. We can always condemn and rightfully condemn anyone who would walk into a school and start shooting. But until we address the actual causes of these events, they're going to keep happening. I hope and pray we do as a society take action to address juvenile mental illness and access to guns, because those two things are always a recipe for tragedy. We need to address internet sites and social media applications that prey on children, that radicalize them, that have algorithms that stir up controversy, conflict, and amplify bullying. What happened at Freeman High School 7 years ago was a crime and a terrible, terrible thing. Many people have been traumatized and will be forever affected by what happened that day. And all of the victims are deserving of our sympathy and support. The one consolation that comes from an event like this is what Fred Rogers talked about after 9/11. On that day, almost 3,000 people died in a terrorist attack. Children across the country were terrified by what they saw on TV. Mr. Rogers, to comfort children, told them, when something bad happens, look for the helpers. Look for the people who run toward the falling buildings, the firefighters, the police officers, the people who risk their own lives. You saw those people at Freeman High School, the heroes who risked themselves. And number one was Sam Strahan, who tried to talk to my client and diffuse the situation. His actions undoubtedly saved lives that day. Law enforcement and first responders were there within minutes. Healthcare workers and counselors cared for victims afterwards. Those are the people who give us hope and show us there's still good in the world. More than any type of crime, school shootings shock us because they are crimes against children. Children who are vulnerable and deserving of our safety and protection. Our children did not ask to grow up in a world where school shootings can happen at any place and any time. But children like my client were also victims of a society that didn't protect them from the influences and encouragement of gun violence. When you sentence my client, we need to look in the mirror, take a good look in the mirror at what our responsibility is to help kids with mental illness who are dealing with school bullies and cyberbullying, who are bombarded by violent images every day, TV, movies, internet, social media, video games, and the news, and most of all, easy access to guns. School shootings should not be a fact of life. They don't happen in other countries. They don't have to be a fact of life in our country. They happen here because we allow them to happen, and we are culpable for their occurrence. On behalf of my client, I want the court and everyone to know that he does offer a sincere apology to everyone who is harmed. He knows he can't take back what he did. He knows he can never fully repay the debt he now owes. He can't bring back the person whose life he took. He can't fully explain what caused him to take the actions he took that day when he was 15 years old, a child with a brain development of 11 or 12-year-old with a learning disability, a child struggling with his own mental health issues, a child who clearly made impulsive decisions without fully comprehending the consequences. He will forever regret what he did. He understands he can never fully make up. He can't have or try to work toward rehabilitation. Prosecutor talked a little bit about closure. That's always a tricky concept because I don't believe that closure can come from a courtroom. There are people who find closure other places. Some find it in their faith, their community, their family, their friends, or through professional counseling. I hope and pray that the people who have been harmed in this case do find closure. In Christianity and in our criminal justice system, we have a tradition and long-held belief that no one is beyond redemption. All of us, no matter what we've done, are worth saving. When we have wronged others, we can and should ask for their forgiveness. And when we have been wronged, we have the power to show grace for those who have wronged us. Caleb isn't asking anyone to forget what he did, and he's not seeking to avoid justice. But he was a child when he committed his crime, and he's here today to take his punishment. He desperately wants a chance to redeem himself and show he can still be rehabilitated. The sentence the parties have agreed to is consistent with the ruling of the Court of Appeals. It provides an appropriate punishment with fair chance for him to demonstrate rehabilitation. We ask the court to follow the joint recommendation. Thank you, Your Honor.
All right, thank you. And before I hear from Mr. Sharpe, I just had one inconsistency that I heard on the count 5, the range was 53 to 70 months. In your written document, you said the court should impose 53 months, but I heard Mr. Jolstad say 70 months.
That was a mistake. That was the range. Judge Price did, in fact, put the low end, so the 53.
53, that's the
Yes.
agreement. Okay. Right. Court is going to have some comments. Before that, though, Mr. Sharpe, you have an opportunity, if you would like to say anything to the court and the courtroom, would you like to do so?
Yes, Your Honor.
Okay. I want to make sure he's on the microphone, so you can be seated if that works for you, if you just bring that closer. If you want to stand, you would need to go to the lectern. So it's up to you.
Everyone in this courtroom, save my parents, has a view of me that is wholly inspired from the evil I committed on September 13th, 2017. I understand, though I know not fully, their anger, their sorrows, and their grief. and I mourn that there is nothing I can do to make up for what I have done. Knowledge of this, I have set out to do the only thing I could, grow in my faith and values, so I could forever put evil behind myself and take on that which is good. For the last 2 years after being sentenced, I have been housed at Green Hill School. Before going, I spent months at jail thinking about what I wanted to make out of this life, now that other opportunities were broadened. I asked my parents to look up what schooling was available at Green Hill. They had told me that it amounted to high school and college. I made a plan before leaving that I would get to Green Hill and immediately inquire in 4 things: the chaplain, college classes, work, my name change. Once I reached Green Hill, I followed this plan, and in short time was employed in school, leading a Bible study group, had my name changed. At the same time, became a spokesman in Youth Voice, a group that worked with the youth and staff at Green Hill to pursue change and effective communication throughout the entire campus. Through this work, I met Jose Kaywood, who also enrolled me in Capital Classroom, a group that meets with senators, lobbyists, and other support groups to help the legal situation of juvenile justice and justice overall. Through this program, I was able to speak at 2 public events in front of many legislators. I also had the honor to speak with many personally. This helped me to use and refine my skills and talents, so I decided to use them more. I worked with the new religious coordinator to set up another Bible study. I also joined her group that was dedicated to bringing our voices to religious needs on site. We worked as an interfaith group to ensure that every member of every faith was represented. With some help from Jose, I also managed to create a culture group of which I will be the facilitator. My college career was and is in the background of all of this. I have a 3.9 GPA. I went through a graduation for my AA just a few months ago. I have worked hard and have been chosen among a few select other residents to join the Baker North program, which is reserved for those residents who are on campus being mentors and doing what we can to change our lives. What I am working on with my friends now, though, will be my magnum opus at Green Hill. We plan to make a group that addresses the needs of at-risk youth, such as myself, such as those I'm working with, so that no one ever has to sit in my position or in any victim's position in a courtroom again. This needs to end, and we want to make it end with whatever we can do. It uses principles from DBT, SEL, and our past experiences to combat the kinds of behaviors that we followed. I seek to begin its trial phases as soon as I get back to Green Hill. I say absolutely none of these things to minimize or to take away anyone's opinion of me or the things that I did to them. But I hope this list of achievements can make it clear that I have forever rejected the ways I walked when I was younger, and I will never again walk in these evil ways, nor will I allow others in my purview to do so.
Thank you, Mr. Sharpe. All right, the court has a few comments, and then I'll get to the sentence. And when I get to the sentence, I'll have Mr. Sharpe stand, but you can stay seated now. So if most of you probably sat through the many witnesses who testified in the previous sentencing and have heard their grief and their bewilderment on our court system, on how it could feel the way it feels and so inadequate for the loss that people have had. And I just wanted to frame it a bit. There was a time long ago when we left justice to individuals, and people would figure out what they thought justice was, and they would just mete out justice if they felt they were victims of a crime or an injustice. And then we decided that that didn't work so well, and then we had a community justice system. It was kind of a direct democracy where something happened in the community would just figure out what they were going to do, and they would just do it without coming to court or anything like that. And yet again, that didn't work that well. And there was a suspicion that emotions were getting in the way, and there was a lack of actual justice. And long ago, before this country started, we developed something in our predecessor countries in Europe, the rule of law, that we would figure out laws. And at that time, we had a parliament that would do it. When we came to this country, it was a legislature or Congress. and they figure out what the consequences are when people break our community agreements, especially the most serious when they take a life. And so we leave it to the legislature, but even the legislature is constrained by the Constitution of the state and the federal government, where the original contract that set up the state and the government set out some parameters in the Supreme Court of the United States and Washington State and the intermediate courts of appeal. They give constraints to the legislature. And as Mr. Joel said, for the prosecutor's office outlined, and Mr. Hargett followed on, in the last 10 years or so, the courts have constrained the legislature. It used to be aggravated murder, which is what Mr. Sharpe pled guilty to, was life without parole. That was just that. But the Supreme Court ruled that that was inappropriate, and our state Supreme Courts have had several cases. You've heard them mentioned: the Miller, the Houston Sconiers, the Gilbert, the Hague, and those cases forced our legislature to change the law for younger offenders, specifically for those under 16 and from those between 16 and 18. And they've limited the sentence. And for those people who lost someone to aggravated murder, it's not going to feel right necessarily. And I spent many decades representing families who lost their children. And I've spent many decades representing children and young people who are on the wrong side of the law. And I think everyone agrees that the legal system doesn't quite fit yet. It doesn't quite feel true justice yet. It doesn't feel that way. And that is the experience that most people in the court have today. And that's how it is. I would contend that it is a better system than any other place that we've figured out in this world. And it continues to evolve. We continue to try to make it better. But our legislature, in response to those court cases, has said that for aggravated murder, the minimum sentence shall be 25 years. And then at the end of 25 years, the defendant has the ability to petition for release if he or she can convince the Indeterminate Sentencing Review Board that they are safe to be released. And that is the case law. Now, it was a little bit of an open question, and the parties could have disagreed, and they do disagree, of whether the court could go below 25 years. But in this case, the defendant waived his right to make that argument, so the court didn't have to go there. If he had made that argument, the case would have dragged on, not just for sentencing, but it would have gone up on appeal, probably to the state Supreme Court. And similarly, there was a question that could have been between the parties as to whether or not a young person under the Miller factors would get a consecutive sentence for the assault and the attempted murder and the gun enhancements, or consecutive, as Judge Price ruled when he applied the Miller factors. Again, if the state hadn't agreed to the joint recommendation that they had, that would have extended everything for years and years. Both sides have told us today, and the court accepts in good faith, that they wanted to get to the end of this and move on to support the closure for everybody, however they find it. So the court has reviewed all those hundreds of statements and thousands of pages of testimony, along with the new briefs from the court and some more information from Mr. Sharpe about his pro-social progress since sentencing of 2022. And the court does have to take into account the Miller factors. The court will largely be adopting the factors of Judge Price. The court will, after today, since I didn't have the benefit of what the testimony, I couldn't do it yet, but the court will enter some specific findings of fact and conclusions of law at a later date. The court wants to recognize that, by definition, even having this resentencing hearing, which was beyond all of our control, is re-traumatizing for both the individuals who are directly affected and the entire community. The court's job at this juncture is to preserve due process for the defendant, for the state of Washington, for the community, for the people who've been impacted directly and who have survived. and to apply the current law as we best understand it to the facts to the best of the court's ability. Unfortunately, the court doesn't have any formal power and little influence over healing the individuals or the community in which they live. As has been mentioned, this has been a particularly difficult week for anyone who's been touched by this type of violence. The court would like to commend the lawyers and the parties for efficiently moving the case forward towards resolution after receiving the mandate back from the Court of Appeals, and while providing everything the court needed to fully consider what happens next. The court commends all of the survivors, whether you testified or not, those that are here and on Zoom and those who are not, for all your participation and following and your concern and care for everyone else that you have provided as we all attempt to heal going forward. The court also would like to acknowledge, Mr. Sharpe, your participation and your statement in the proceedings, your decision to plead guilty and accept the state's offer of sentence with a goal of ending the litigation, and your continued efforts to rehabilitate yourself and be a service to those around you. If you would please stand, Mr. Sharpe, I will announce the sentence. In respect to count 1, aggravated murder, the court will follow the recommendation of the parties after considering the Miller factors and all the evidence previously discussed, and will sentence you to 25 years minimum to life, subject to review after 25 years by the Indeterminate Sentencing Review Board, and lifetime supervision by the Department of Corrections, with the same conditions that were set out by Mr. Jolstad that were previously, including no contact with all the named victims to the extent as allowed by law, plus the 60 months firearm enhancement to run concurrently. For counts 2 through 4, attempted murder in the first degree for 3 different victims, the court again follows the joint recommendation, and similar to Judge Price, 240 months for each count to run concurrently with all other counts, and 60 months firearms enhancement for each count also to run concurrently. And for count 5, the second degree assault, the court adopts the joint recommendation of 53 months to run concurrently with all other counts, and 60 months firearm enhancement also to run concurrently. Court also sentences you to a restitution amount of $39,961.83 for the victims as previously determined by the court, with the same payment plan of at least $25 per month. The other legal foundation is in terms of them that were previously ordered. The court has found previously that you are indigent. The court finds that you remain indigent and therefore does not impose any other legal financial obligations. And with that, the court will sign the judgment and sentence once it's presented in the warrant of commitment when you present it to me. And if you can get that done today, you can do that today if we need another day. I also would like to see a signed notice of rights to appeal. Okay, and with that, you may be seated, Mr. Sharpe.
Says you have no prior criminal history.
And the court is in a soft recess at the moment while he's preparing documents.
It looked like someone who knew what they were doing. Is that right?
Yes, sir.
You believe this was a professional hit?
And that's what I believe.
Okay. And you believe this killer is kind of almost like someone hired to do this job, like an assassin, essentially, right?
And that is what I believe, yes, sir.
All right. Now I want to take a look at this picture for a second. the assassin seems to be wearing a giant sun hat. It's a pretty big hat, right?
Yes, sir.
It's fairly noticeable, right?
Yes, sir.
You think that might attract attention?
I would think so.
Okay, but this is a professional.
Right.
All right. And this professional is also wearing a bright orange shirt, correct?
Yes, sir.
Professional?
Yes, sir.
But wouldn't that attract attention?
I think that's part of the reason, actually. If I could elaborate.
No. You believe that professional assassins want to draw attention to themselves when they're carrying out murder. That's your testimony?
When they're framing someone, yes, sir.
So the answer to my question is yes. You believe professional assassins like to draw attention to themselves.
It depends on what the nature of their goal is, and if it's to frame someone, yes, sir.
So the answer to my question is yes.
Yes, absolutely.
Okay. Your professional assassin is wearing a big saddlebag, right?
It's a big bag.
Right. He's wearing Nikes, correct?
Correct?
Not generic shoes, Nikes, isn't that right?
Right.
Okay. Gray Nikes, is that right?
Correct.
All right. Let's cue over to the overhead, if we could, or to the computer, if we could. All right. I'm playing the PIO video from Exhibit 338. So this is your assassin walking in the middle of the day, correct?
My assassin?
All right, this is the assassin, the killer, correct?
Yes, sir.
All right. Seems to have a little bit of a hitch in his getup.
Yes. I don't know. I guess it's an opinion.
And you don't disagree that's from, you've seen all the footage, that's the killer's car, right?
Yes, sir.
It's a maroon Denali, am I right?
Yes, sir.
You own a maroon Denali, isn't that correct?
I do, sir. Yes, sir.
Let me at least let's look at it for a second. So there's no doubt that the killer took a maroon Yukon Denali to Garriman's house to perform, as you have explained to us, to be some sort of professional hit.
Yes, sir.
Okay. So I'd like to publish the PowerPoint, if we could. It's still from Exhibit 338, Your Honor. But it is the PowerPoint video. And I want to turn our attention to slide number 72. This is after Mr. Garriman has been killed, but if we watch this footage, isn't it true that we see the killer come back to the scene?
Yes.
And the killer seems to be looking around as if he forgot something, right?
I've watched the video. I don't know what he's doing.
We don't know.
Right.
But we know a professional killer killed someone in broad daylight, made it a point to park on a completely different street, but then for some reason decided, oops, I forgot something, and drove all the way back.
My belief is that he wanted to make sure to commit the crime, and then when he was done, he wanted to make sure the SUV was seen in front of the house.
So let me get this straight. We've watched the footage, right, Mr. Tellis?
Yes, sir.
Isn't it true that the Yukon parks on Wintergreen initially?
I'm sorry, I wasn't paying attention to the streets, but I mean, if you say so, yes.
We'll put it to you this way. He didn't park on Bronze Circle, did he?
Not initially, no.
And by your logic, if the killer wanted to be seen, shouldn't he have just parked on Bronze Circle originally?
Well, I would have thought that, if he wanted to make sure he got the job done first, that he would not have actually parked the SUV in front to begin with.
Oh, so
that's my belief, because,
okay.
again, that isn't me.
So you have a killer who goes all the way out of his way to park on a completely different street, walks the whole length, does the killing, drives out of the complex, and then makes a U-turn, comes all the way back into the complex, pulls up, gets out, looks around for something, and you believe that's all part of the assassin's plan?
And again, I don't know what he's doing in that video.
No, I'm just using your words,
no,
your thought process.
absolutely.
You believe that was all part of the plan?
I do. It wasn't me, so
Sir, doesn't that look a little amateurish?
I would like to think that I wouldn't use my own car if I was actually the person who did this.
Well, it's-
So,
Well, doesn't it look a little amateurish to take the steps to park on the side of the street, then you forget what you dropped, probably your murder weapon, who knows, wear this goofy sun hat, a bright orange shirt. I mean, you really think that looks like a professional killer?
I do. Yeah, again, it was.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the